Welcome back to Evelyn the Advocate. I'm Dr. Evelyn Denise Hemphill. Today, we step into our educational series, Practical Knowledge that every survivor, every advocate, and every family member touched by domestic violence deserves to have. Let's get right into it. How abusers use family court and what to document. Family court operates on a different standard than criminal court. Decisions about custody are made based on the preponderance of evidence and the court's assessment of the best interest of the child. A judge with no training in domestic violence dynamics can look at an abuser who presents as calm and child-focused and a survivor who presents as anxious and traumatized and conclude that the calm party is the better parent. Trauma responses are predictable results of sustained abuse. In a courtroom, they can look like instability. Post-separation abuse through the legal system follows predictable patterns. Filing repeated motions to drain financial resources, making parental alienation claims when the survivor attempts to protect children, and presenting in court as cooperative while continuing to harass outside of the court. Document every incident of abuse with dates, times, and witnesses. Preserve text messages, voicemails, and emails showing controlling behavior. Keep records of any police reports. Document patterns of behavior towards children. If a guardian ad litem is appointed, know what they are supposed to do. They are supposed to interview you, your children, the other parent, and significant witnesses, and visit both homes. If the GAL is not doing these things, document that failure in writing and raise it with the court. Key takeaways. Domestic violence training for family court judges is not required in most states, so you must educate the court yourself. Bring documentation of the cycle of abuse, evidence of coercive control patterns, and if possible, the testimony or statement of a domestic violence advocate. Parental alienation claims are frequently weaponized against protective parents. If you are limiting your child's contact with an abusive parent, document your reasons clearly why. The concern is safety, not alienation. A guardian ad litem who does not investigate thoroughly is not fulfilling their obligation. You have the right to request a different GAL or to submit written objections to a GAL report before the hearing. The courtroom is not neutral, but it is not closed to you either. What you bring in determines what can happen there. In the next episode, we talk about navigating the legal system without resources, what pro se litigation involves, where to find legal help, and how to represent yourself effectively when you have been financially depleted.